House Division 1 is now in session.
Good morning, thank you. Please be seated. We are here in our cause number 1CA CV12-0765 in the matter of Arlene Natale versus Paul Natale. This is the time set for oral argument. Each side will have 20 minutes to argue their positions. If Mr. Murray, you would like to manage your clock and save some time for rebuttal, we will allow you to do that. We're recording this audio, so as you come forward, please identify yourself and your client. And we're also recording this by video, so smile nicely for the camera.
Where are those cameras?
I don't care. We have read the briefs in this matter. We've conferenced it. We issued the order asking you to touch base with respect to the jurisdictional issues that have been raised by the appellee in this matter, and I think we're ready. So with that, Mr. Murray.
Thank you, Your Honor.
Bless you.
May it please the court. My name is Stanley David Murray. I'm representing the appellant, Paul Natale, who was the respondent in the lower court proceedings.
You said that Natal?
Natale, I believe, is the way they pronounce it. Your
Okay.
Honors.
Two syllables, not three?
Natale.
Natal.
Correct.
Okay. We were internally not saying it quite right. We'll
No
try to
problem.
We'll try to get it right.
I would also like to reserve 5 minutes of my time for rebuttal. I had some great substantive issues I wanted to jump into right away, but I better deal with that jurisdictional issue or else all that's moot if we don't agree that you do have jurisdiction. The Reek versus Mendoza case just came down recently. At the time this appeal was filed, it was in September of 2012. And so apparently the appellee's position is that Reek should apply retroactively. And under the general rule, cases do apply retroactively. Court opinions do apply retroactively. But first of all, I'd like to distinguish Reek from our situation. In Reek, the Court of Appeals seemed to be concerned about the fact that the prevailing party, or the party who was awarded attorney's fees, had not yet instituted proceedings for her application for attorney's fees. So there wasn't anything pending in the Superior Court at the time the notice of appeal was filed. In this case, the applications for attorney's fees were pending, and so there was an ongoing matter that could not be interrupted, I feel, by the Reek decision. Because Reek said...
We're talking about the August 9 signed minute entry, and then the August 24 and September 17 judgments for attorney's fees, and then your notice of appeal on September 24.
Right.
And you're talking about the fact that the August 9 didn't wrap up everything.
Because the applications for attorney's fees have been made prior to that August 9th decision, whereas in Reek, we had a decision, and then there wasn't an attorney's fees application pending. So I'm distinguishing it on that basis.
We're willing to hear argument on why we should follow Gadimi instead of Reek anyway.
Well, yeah, I think Gadimi is a case that applies here, not only because it was an appeal that was filed when Gadimi was in effect, but also because Gadimi is the proper interpretation of Rule 78, that I don't think the Reek, and I don't mean to criticize your brethren, but they didn't get into the 78 provisions as to when the attorney's fees has to be determined. The Reek case only looked at 78B and compared it to 54B as to when the attorney's fees are to be awarded. And 54G, read in conjunction with 54B, says you have to determine attorney's fees at the time you make your decision. Well, the Reek case said under Rule 78B, they don't have a similar provision, and so it's different than family court. Well, it's not different in family court because Rule 78D is exactly the same as 54G. And the Reek opinion didn't discuss that or didn't go into that. So I think that's another reason why the decision is incorrect and should not be followed, let alone if it should even be applied prospectively.
Is there any reason for why our Supreme Court in the Craig decision only looked at 54B and didn't look at, because it clearly existed at the time, the family court rule?
I don't know. I thought the family court rule wasn't in effect then because they made a motion for new trial in the Craig case. Wasn't that under Rule 58? I'm not
Well,
familiar with the facts, and Craig,
I
honestly.
say there, not all of the rules of civil procedure which were moved into the family law rules made it. And so I think Rule 1 of the family law rule says, to the extent that we haven't done something, you can still use the family court rules. But I thought 78 was part of that at that time.
Right, it might have been. But again, the Gadimi Court was correct when they said that Rule 78B is exactly the same as Rule 54B, as did Division 2 in the CASA, in remarriage at CASA case. So I think the REIT case might have used, or could have used a little more briefing on that issue to determine if any differences existed between 78 and Rule 54.
I don't think it probably makes any difference here, but do you have any comments on the meaning of 25-325?
Exactly. 25-325 wasn't enacted to overrule the procedural rules. What the legislature was intending then was so that people who are getting divorced are divorced once a decree is entered, and that an appeal doesn't stay the effect of that order, just like an appeal doesn't stay a child support order or a spousal maintenance order, which is what that statute also addresses. But it wasn't meant to circumvent the procedural rules, because that's in the court's jurisdiction, not the legislature's decision. So, and again, the court in REIC even expanded it to modification cases. So when you have a 25-327 petition to modify child custody, what's going to happen? You're going to have a petition to modify child custody, legal decision-making authority. Then you're going to have a later decision on parenting time. Then you're going to have a later decision on child support and a later decision on attorney's fees. So you're going to have intermittent piecemeal appeals under the REIC decision if it's applied as it's stated, which, as a matter of fact, is happening to me in another case right now.
Well, we do have in family court, unlike most situations in what we might now call civil court, we do have repeated needs because of the ongoing nature of the process, repeated needs for appeals, right?
No, because we have Rule 78B. Rule 78B says we have a number of claims that have to be decided, including attorney's fees. And if you don't put that language in there.
But we kind of, excuse me for interrupting, but don't we kind of wrap each, we have the initial proceeding and there's a decree and maybe further rulings that finalize that. And then there's as here, there was a petition filed in January 2012 that ultimately led to the August 9 ruling.
Right.
And then the two attorney's fees rulings. But that's all, I mean, and to be careful here, that's what's on appeal here, right?
Correct. Not the decree.
I guess nobody appealed the decree?
No. And if one of the parties wanted to appeal it, they had 30 days from the date the decree was entered, which was back in September of 2012, I believe.
Well, assuming it was final.
It
It would have been because of the language. I'm sorry.
I think what Judge Gimmel is just saying is that in the life of a family court dispute, especially with their children, it can range multiple years until the kid's 18 or longer if there are rearages, but that each time the court resolves whatever the issue is, that would give rise to a final determination, maybe with or without Rule 78 language.
That's true. But again, under Rule 78B, I think the trial court can say whether this is final or not if there are other issues like attorney's fees to be decided later. So, and then finally, if REIC is law, valid law, it never did reverse Gadimi, so we think Gadimi would apply to the earlier notice of appeal. But as far as applying Gadimi or REIC retroactively, under the Chevron analysis, the three-factor analysis, we wouldn't want to apply REIC retroactively because it overruled clear and established precedent. Gadimi finally told us family law attorneys when to appeal, because believe me, there's been a number of issues before that. We had the Universal Underwriters case that said, hey, if you haven't decided attorney's fees yet and you filed a notice of appeal, too late because the court loses jurisdiction. And then we had another slew of cases, the Citizens Council case, and on and on. Finally, Gadimi told us, you wait till the attorney's fees issue is determined because that's a separate claim, and unless there's 78B language, you don't have a right to appeal. It'd be premature, which would have happened to us if we did file 30 days after that August 9th decision. The second analysis, retroactive application will affect the prior purpose of the rule. Well, again, under REIC, we're going to have these piecemeal appeals now, and that's what Gadimi tried to avoid. We want to have a final decision, all issues resolved, and then you can do your appeal. REAP would set that aside and cause, I think, a lot of confusion and piecemeal appeals. And the obvious adverse and inequitable results, well, to my client especially, and anybody else that followed the law that existed when they did file the notice of appeal, now they've been wiped out from their right to have this court determine the substantive issues.
I would just say to you and all family law practitioners, if you have the opportunity to try to get one of these cases up to the Supreme Court, we need their guidance as you need it even more, but we need it as well. And we're not able to overrule each other's opinions. We just do the best we can with each one we get.
Yes, and now that there's that Division II case, it's contradictory to REAP.
CASA?
CASA, yeah. I do have an attorney friend of mine told me she's taken up to the Supremes, and I don't know if they've granted review yet, but it is at issue.
Good. Maybe we'll get further guidance from them.
That'd be nice. So on to the merits, if we will. House valuation was the first issue we wanted to address. The court has reviewed the decree that says husband has the right to purchase at a price the parties agree to. Kind of vague, and again, I don't know how to say it, but if the wife didn't want to settle the case, she didn't have to because there was no guidelines as to what was a reasonable offer. My client went out and got an appraisal done just about the time the decree was entered, appraising it at $685,000. Well, wife said, no, you can't buy it at that price. But wife didn't offer a contradicting value. In fact, she counteroffered to buy it at the same price. So you see some exhibits that we've submitted prior to the court, to the trial court, asking for reconsideration of that ruling, saying, hey, she's counteroffered at $685,000. The parties have an agreement. Obviously, $685,000 is the agreed upon value for this residence.
Was she obligated to come up with a different number?
Well, the issue was whether she was being reasonable in rejecting his offer.
Isn't the issue is whether they agreed on a price, and it's clear that she didn't agree. She was just basically saying, I obviously think it's worth more. In fact, I'm willing to, if that's all you think it's worth, I'll pay you that amount and I'll take it. But it seems pretty clear that she didn't agree that that was the value of the property.
Well, I don't know. If she made a counteroffer for that same price, it seems to me she can't now say, hey, that's not a fair price, if she was going to pay that price. But as far as whether she was obligated to accept that offer.
My question was, is she obligated to come
up with a different value?
A different value?
Yes, because otherwise my client's at the mercy of one of the parties. It's not a fair and equal division if one of the parties can decide what the price is going to be or simply say, no, we're not going to sell it or buy it.
It isn't. If you simply say no, then don't you just have to get some type of independent appraiser to come in and set the value?
Well, that's what I think would be her burden, because my client did come in with an independent appraisal, $685,000.
But if she disagrees with that, then don't you go to the court and say, look, we just haven't been able to agree on the price?
Well, that's what happened. And I think what the court should have done at that point was either say, okay, is this reasonable? What is your value? To the wife, saying, why aren't you accepting this offer? And if she can come up with the evidence then to show why it's unreasonable, then fine. The next step was to appoint a special commissioner, which the court did do despite denying our motion and not having a further hearing as to whether her denial was reasonable or not. So we go to the special commissioner procedure, and he gets another appraisal, this time at $735,000. And his question wasn't whether that valuation was reasonable, because again, the wife would not allow the husband to purchase it, but who had the right of first refusal, who had the right to purchase the property first. The problem with the order appointing the special commissioner was that it seemed to say either party could purchase, whereas the decree previously had said husband could purchase. So I can understand the special commissioner's conflict, but the court had no business setting another hearing on valuation, because at that point, again, wife made another counteroffer for $735,000. So at some point, when she's making these
wife had made
counteroffers,
this offer to buy. If we just interpret that as her saying, look, this is clearly too low, so somebody's going to benefit, and if you really think that's the value, then I should be entitled to buy it. But I assume she hadn't made an offer to buy. She just said, I just disagree with these appraisals. What would your position be there?
then her burden was to prove what it was worth.
But
At the time, by the way. That's another issue. I'm sorry, go ahead.
But why wouldn't it be if the original order was to if you can reach an agreement, then it will be sold. If they haven't reached an agreement, where do you come up with the time for fixing the value of the property?
When my client first made the offer to purchase, whether that $685,000 offer was reasonable or not. For the court to allow the wife to control the situation, simply not agree, we don't think is fair and equitable, because it's caused all these proceedings to drag on with more attorney's fees. But if the court had interpreted its decree properly, the question should have been, okay, wife, you don't think 685 is reasonable, what is reasonable? The trial court never did that. So the wife had the sole authority, if you will, to say, no, rejected, nope, rejected. Finally get up to $760,000. And again, that value was based a year after the fact my client had first made his offer. And there wasn't even any testimony to support the increase in value as being simply due to the innate quality of the house. It could have been part of the efforts and labor that my client had put into that property. So we think under sample, it should have been valued as of the date my client first made that offer back in August of 2011, rather than keep on going and going with more and more hearings and more valuations. Second issue is the non-qualified retirement plan. I think Bonkoski is dispositive of that issue. I'm down to 5 minutes, so I'm going to wrap it up real quick. Bonkoski simply says you can't distribute assets presently, retirement assets. You have to wait till they're in pay status. So it asks the court to take a look at that ruling. The husband's reimbursement claim was the interesting issue I wanted to get into, and the brief pretty much covers it. But here's a situation where sole and separate effort is being used to improve the value of property after the community has terminated. And we think under the Garrett case, the community doesn't benefit from sole and separate efforts. That husband is entitled to a claim or a lien for reimbursement.
What was the theory that was advanced? Was it that I'm a contractor? Did he allege that? Did he raise an unjust enrichment claim, or what was the theory that was advanced?
It wasn't so well stated as a quantum merit claim. Instead, it was actually raised in the pretrial statement submitted by wife that husband was claiming a 20% contractor's fee as a reasonable value for the services that he had rendered. And that's what the position that he took during the trial.
It wasn't based on a notion that he contributed separate funds. It's based on the notion that he contributed his labor, which at that point was separate.
Separate effort, yes, sir. And that's what the, on the opposite side of the community lien issue with Valento and Jedniak and those lines of cases, it can be contributions in terms of cash or labor that improves the property. That's what we're making this claim here. I'm going to save my time unless the court has any further questions. Thank you, Your Honors.
Thank you.
Good morning. I'm William D. Bishop on behalf of the petitioner, appellee Arlene Natal. If I may, I'll start off with the jurisdictional issue, since that's the first one that was addressed by the court and Mr. Murray. The Rigg decision, I think, is very, very clear from the language regarding the distinctions between the rules of civil procedure and the family law rules. In this case, Rule 78B of the Rules of Family Law Procedure specifically state that a claim for attorney's fees may be considered a separate claim from the related judgment regarding the merits of the case. So the family law rules have recognized already that attorney's fees can be dealt with separately, as opposed to the civil rule 54G, which states it's mandatory that a judgment not be entered until the claim for attorney's fees has been addressed in the judgment. Now, Mr. Murray stated that 54G of the civil rules is identical to 78D of the family law rules, and that's not accurate. Rule 78D provides discretion to the trial court whether to include attorney's fee judgment with the merits or separately. So the court, when they drafted the rule, they already recognized exactly what the court's brought up today, and that is that family law is a whole different animal than civil.
But isn't the statement in Rule 78B that attorney's fees may be considered a separate claim, isn't that confirmatory of the need that if you're not going to wrap up all the claims, you need to either wrap up all the claims, and the attorney's fees is a separate claim, or you need to have Rule 78B language for finality. Just like 54B language.
I think the key word on that is may. So it may be considered a separate judgment, may not, and that's where we go to 78D, which provides the discretion to the trial court. Does that answer your question?
I think so.
Why
this-
would we apply REAK retroactively here? What would you have done in opposing counsel's position? Don't you follow Gadimi's out there? What else should they have done? Shouldn't they have followed Gadimi?
I think that's a great question, and I think the bottom line is that the case law wasn't completely clear up there. You know, somebody has to assess the roles and make that distinction themselves because the case law really hadn't been gone to the full extent yet at that point. So what I have done, I would have filed 2 notices of appeal. In the exercise of caution, I would have done it right after the first signed judgment was done, and I also would have done it after the attorney's fees.
Without REAK, we wouldn't be looking at any kind of concern with what counsel did in this case.
You know what? I think that would be speculative on my part. I'm not sure what I would have done. I don't know if I would have tripped across the same arguments that were made in REAK. The fact of the matter is the REAK arguments were not made in Gadimi, but also jurisdictional is supposed to be a bright line. It's not a kind of a changing line. We need to decide one way or the other. Is there jurisdiction? Is there not jurisdiction?
But in REAK, there was nothing that was going on in the trial court. No one had filed a request for fees, so somebody had to try to get the case moving. As opposed to in this case, there was something still pending.
That's correct. There's always something pending in this case. In all honesty, this case has been a rolling ball.
Isn't that very different than from REAK?
Well, I think it's a distinction without a difference that Mr. Murray made, because there's nothing either in the REAK decision that says that there has to be a pending application for attorney's fees for it to apply. And as far as the retroactive application, the Chevron exceptions don't apply in this case. And one of the things that Mr. Murray argues in his brief is that this is a harsh result because REAK came in after the fact. And the bottom line is there's no harsher result than there was in Gadimi. In Gadimi, there was an early notice of appeal filed. It was found to be premature, and thus the appeal was dismissed. So actually, it was probably a harsher result in the Gadimi case. So it's kind of one of those, I guess, harsh realities that we face at this particular stage. Moving on to the merits, unless there's any more questions on the jurisdiction.
The only other thing I would say, since I have 2 family lawyers in front of me here, is you know, the civil rules are being amended effective January 1. But as far as I know, the family rules aren't. So perhaps the family law section of the bar would want to seek some similar rule change to help solve these problems that make it so difficult for practitioners to know when or how often they have to appeal.
That's a very good point.
We're trying to do our part, but we don't have the final say.
Yeah.
That's all my speech for you guys.
Very good.
Take it or leave it.
Moving along to the merits. Oh, I'm sorry.
Go ahead.
Moving along to the merits on the home, first of all, the $685,000 issue is old news. It wasn't not brought up during the enforcement proceedings. It wasn't addressed in the pretrial statement. It wasn't addressed anywhere. It wasn't even mentioned in the testimony. The appraisal that led to the $685,000 wasn't an exhibit. The only way it would even be before the court is if you look back in the prior pleadings that were filed in the post-trial motions, in which the the husband in that case tried to convince the trial court to adopt that and said that there was a implicit agreement. The trial court turned that down, denied the post-trial motions, and those post-trial minute entries were not appealed. But and I think Mr. Murray in his briefs brings up the fact that those minute entries were not signed, but at the same time, that issue was never raised again for purposes of the enforcement proceeding. So the $685,000 figure is off the table. As far as the $735,000 figure, a review of the transcript shows that the husband in this case didn't present any testimony as to that value. He just merely told the judge, I want to buy this property at $735,000. The trial court was pushing him because he was running out of time and he had not really addressed the issues in the enforcement action. So she finally, the judge said, you need to address these issues in the enforcement action. She said, what about the house? He said, I want to buy it at $735,000. But there was no evidence. He didn't even testify that he thought that that was the appropriate value rather than the $760,000.
There was not an appraisal underlying that value?
There was an appraisal underlying that value. That is correct. But he did not testify that he thinks that's correct or why that should apply rather than the $760,000 value. The wife, on the other hand, did testify that the $760,000 was more reliable than the $735,000 value, which was done by the exact same appraiser. The only difference between the two valuations was the time that had passed, because by the time we got to court, several more months had passed. At that time, the market conditions were changing. There was testimony by both the special master as well as wife that the 3.3% increase in the value was reasonable in light of the market changes. And as we sit here today, a year later, the market has even changed more.
Could you address husband's contribution to his work on the house?
Yes. Husband admitted in the trial transcript that this was a voluntary thing that he did. He said, I voluntarily was, or actually I believe it was in the opening brief, he argued that he voluntarily did this on behalf of the community. In this case, the trial testimony shows that husband basically ejected wife from the home. Neither one of them were supposed to be in the home because the insurance company...
To conclude that it's voluntary on behalf of the community, if at this point it's clear that the marriage is over, why would it necessarily be on behalf of the community?
Well, just because that's what they said in their opening brief. So I was citing their opening brief, what they actually said. But the fact of the matter is that, and it's right in the decree, that wife contested husband excluding her from the residence and excluding her from the renovation process.
The home still had its community nature.
Excuse me?
The home itself, the house and property still was community.
Correct.
Until sold and divided, whatever.
That's correct.
That continues after the petition.
Yeah. And it was undisputed. There was no agreement by wife that husband was going to get a general contractor's fee. There was no dispute that husband never brought it up.
Was there a general contractor?
No. No. Husband forged wife's signature to the insurance document so he could act as a general contractor, which is also in the record. So he not only excluded her from the home, and as the trial transcript shows, made threats against her if she comes to the home, and forged her name on the insurance checks and forged her name on the insurance documents in order to force himself into this role that wife did not want him to do.
But excluding her from coming in, how does that change the nature of kind of benefit that's provided?
Well, remember, husband didn't actually pound the nails or anything. He wasn't in there doing this stuff, hanging the sheetrock.
I'm assuming a contractor doesn't do that either.
Right. He hired the subs.
Okay.
Right.
But assuming, so keeping the wife out of the house doesn't really change kind of what a contractor would have done or what he did if he contributed some separate, his own time as some separate value that increased the value of this community asset?
Well, I mean, true, she didn't have to be at the house to hire the subcontractors, but she did need to be at the house in order to decide what tile you're going to use for this, what paint colors and all those sort of things, which she did during the first few days until she was excluded.
But is that what he's seeking compensation for, kind of making decisions on colors, that type of thing, or is it more acting in the role of the contractor?
Well, the way he expressed it during trial was acting in the role of the general contractor. There's been a little bit of a sliding. There's been different types of claims that have been made really in the appellate briefs than that were actually made at trial. At trial, he just said, hey, I act as a general contractor. I should get a 20% fee. There was substantial evidence that was brought up by wife on why he should not be entitled to that particular fee, not just because he wasn't a general contractor, not just because there was no agreement. Remember, general contractors, they have insurance, they have certain quality levels they have to rise to. None of that was here.
What was the evidence that you're referring to that wife brought up?
The wife brought up evidence that not only was there no agreement, not only was she improperly excluded from the home despite the court orders that he was not to have exclusive possession, but that Well, one of the things we brought up on appeal is that husband never provided any evidence regarding what he really did other than act in this role. And so they've had two different theories. One is the general contractor and one is the value of services. We have absolutely no evidence on the value of services. Another thing that wife brought up is it wasn't just husband acting in this role. The parties jointly hired a public insurance adjuster to negotiate what the insurance proceeds were, and there was also appraisers that were hired by the community to go out there and appraise these particular things that needed to be done on the home. So basically what it comes down to is, at least as far as the record shows, that husband hired the subcontractors.
Why wouldn't he be entitled to something for that?
Well, number one, not only based upon the facts, and the trial court was certainly in a position to review all the facts and to determine whether he'd be entitled to some kind of compensation, but number two, is never pled. He never filed a counterclaim. He never filed any pleading requesting this. He also didn't include it in the pretrial statement, thus he's precluded under Leathers v. Leathers. The only reason that the claim was brought up as a defense is he did put it in his resolution management conference statement, which he filed the same day. So wife addressed this in her in her pretrial statement in the exercise of caution to make it very, very clear that she disputed this. There's a difference between a general contractor being able to fix his own home versus somebody who's unlicensed who gets to charge other people. And I think the statute is very, very clear that somebody cannot get compensated for being a general contractor unless they're licensed. You can certainly fix up your own home, but without an agreement, that doesn't mean that your spouse has to pay you for those efforts. And in this case, these claims were never even made until right before trial, and they weren't preserved and they weren't pled in the proper manner.
Presumably, if he'd gone in and done some particular labor, like had put in the tile himself, would you agree that he'd be entitled to something?
Not under
for
these
that?
cases because of the procedures, because of the fact that there was no agreement or anything else. For instance, I mean, I don't want to get extreme, but people all the time, spouses all the time, will take care of marital residence. They'll go out to mow the lawn, they'll pick up the dog feces, they do all these things. Does that mean that they're entitled to reimbursement for their contribution during the severance of the community?
Yes, please.
But it seems a little different to me than if husband is the person who's actually doing the labor. It's my hypothetical that he's actually putting the nails in, he's actually putting the tile in, and it's clear that labor is worth something, whatever the going rate is for that type of labor. That seems different to me than mowing the lawn or.
Perhaps, but in this case, if perhaps there could have been a quantum merit claim if he could show detrimental reliance, but it wasn't properly pled. And in this case, wife explicitly objected to being excluded from this process, which is different than I think what happened in a quantum merit claim.
Well, in this house, at least slated to be sold, whether to one of the parties or to a third party. So at least your argument is that even under a quantum merit, he would still probably need a contractor's license.
Yes.
Because it wasn't just merely that he had already bought it or she had already bought it and they were fixing it up, but it wasn't going to remain in the family. Potentially it was going to get sold.
Or he certainly has been expressing since day one he wanted to buy it, but we've already addressed that, I think, in pretty detail. But, the fact of the matter is even if I was a licensed contractor, I can't go to my neighbor's home and start making improvements against his objections and claim quantum merit because I improved the value of his property. I think there needs to at least be some facts that support the fact that he was led to believe he would get some kind of reimbursement for this. And this dates all the way back to Cree. He was doing these, he was involved in this process before the parties went to trial during the divorce. It was never raised. It was never raised at any time. It was never raised in the post-trial proceedings. He didn't raise it until it was a defense to the enforcement action. It's too late, and he didn't go through the proper procedures to get there. As far as the distribution of non-qualified accounts, Mr. Murray stated that the Benkowski case says that the court does not have the ability to order the division based on present value, and that's actually incorrect. That's not what the Bankowski case states at all. Bankowski adopts Johnson v. Johnson. They completely leave it up to the court's discretion on whether it should be pursuant to a reserved jurisdiction method or a present value payout. In this case, the facts were even stronger. They were in Johnson v. Johnson. The trial court specifically found that husband had not complied with the decree, and it was a continuing situation, and adopted wife's concerns that if husband was order to pay this when he actually received it, since it wasn't by a quadro, they couldn't do a quadro since it was non-qualified, that the present valuation payout should take place. Husband, in his brief, also raised the argument that that there was language in the Bankowski case that talks about that it would have to be set off against assets that had not yet been distributed. And in this particular case, the house has still not been distributed, and husband has not complied with a number of the judgments in the decree. So the assets have not been distributed yet, and there's absolutely no distinction between this case and the Johnson case, other than it's even stronger. The trial court, even at wife's agreement, even went so far to say if husband didn't receive these assets, Southwest Airlines goes out of business, that wife would have to reimburse husband for this. With regard to the attorney's fee judgments, the record, the attorney's fees are very much supported by the record. There were numerous exhibits that show that husband was not compliant with the court orders, that husband made misrepresentations during trial, that husband did not comply with the discovery and disclosure requests, and this is all laid out in excruciating detail in the applications and the replies for the attorney's fees. Husband was pro per at the time, and I think the record shows that he was a little bit of a moving target, and took a lot of actions that were unreasonable. The court, in its minute entry, was very specific, stated that wife took no unreasonable positions during the enforcement proceedings, and that husband took numerous unreasonable positions, and laid out all those unreasonable positions, including husband forging wife's signature on the insurance documents, which put him in the position to even be able to act as a general contractor, as well as forging her name on the insurance checks so that he control all the insurance proceeds, and basically excluding wife from the process altogether. All of the issues before the court, we believe, is subject to Mitchell v. Mitchell, and that is that the Court of Appeals must review the evidence in the light most favorable to support the findings, and must uphold the findings of the trial court if there's any reasonable evidence to support them. In this case, neither party requested findings of fact and conclusions of law, and thus we need to defer to the trial court being in the possession to hear the evidence, determine the credibility of the parties, which the court actually expressly addressed the fact that it did in its minute entry, reciting the reasons that it awarded the attorney's fees. Every one of these cases is subject to that particular situation, that there are credibility determinations, etc. Husband didn't provide a whole lot of evidence at trial. He basically used a lot of his time arguing points that were really irrelevant, as the trial court brought up numerous times to him. So a lot of the arguments that are being made today are really kind of being pulled from old pleadings and things like that weren't even at evidence. So I would just request that when the court certainly take a look at what was actually admitted into evidence, and determine whether there is even adequate, even a question on whether the evidence is inadequate to sustain the findings. It looks like I have 7 seconds left, so I'm going to sit down, but I'll answer any more questions if you have any. Thank you.
Thank you. Thank you, Your Honors. On the reimbursement claim, Mr. Bishop says that wife never agreed that husband could do all this contracting work. Well, that's not a surprise. It's a family law case, and after a divorce decree has been entered especially, they're not exactly going to be seeing eye to eye on any kind of activities that would benefit a community asset such as this house. Somebody had to take care of it. If they had hired a contractor, even Judge Sanders had asked my client about that, so you took on this contractor's role, why didn't you hire a contractor? Well, he saved the community a great deal of money by putting in his own effort, not only in regards to the increased value of the property, but also in regards to the insurance proceeds. My client went out and worked with the public insurance adjuster to get the rates of the insurance payment rated up from $92,000 to over $240,000.
Why would he be entitled to do that without consent from the other owner of the property?
working with the public adjuster?
Just acting in the role of a contractor.
Because somebody had to do it, because it had to be done, and it saved the community money. It was the
But
benefit that was bestowed.
Isn't there also a risk of, if two people own something and someone just says, well, I'm gonna do this, who's not a contractor, wouldn't the other person have the right to say, well, no, I realize it might save some money in the short term, but I would rather have it done by a contractor? Why isn't that a reasonable position to take if you're the other owner?
It would be if she had done something in regard to that objection. She should have gone to the court and said, keep husband off this property. It's community property. I don't want him working on it. Instead, she apparently voiced her objections, but she didn't do it in court. She didn't ask for a court order excluding both of the parties and requiring them to hire a contractor. And why would she? It's increased the value of the property that she's going to get when her equity is paid out. So there is a quantum merit claim there because there has been a benefit bestowed.
And how was that pled? I mean, isn't there some obligation on your client's part to detail the work that's been done? He's not a contractor, so he's clearly not entitled to just a contractor rate, or at least that it would seem odd to just automatically give him a contractor rate. But wouldn't there be some requirement that he specify, this is the work that I put into this, this is why the community would be unjustly enriched if I were not compensated for what I did?
Yes, Your Honor. I suppose he could have kept a timesheet and determined what a reasonable hourly rate would have been for somebody performing these kind of services. He's not a general contractor, but he did question Wife's expert about whether he had to be a licensed contractor to work on his own house, and that guy said no. And he also established that 20% was a reasonable rate for a contractor's fee through that expert's testimony. So I think he's met that burden of proof because he had no other way of proving it. I mean, he could say $40 an hour is reasonable, but again, he'd be relying on what a contractor would charge. So I don't know how he could either quantify it, than either say that 20% is what the expert said is a reasonable fee.
But he said that's a reasonable fee for a contractor. We don't know that he did everything that a contractor would have done, and it seems like it might have been more reasonable to actually put down the hours that were.
I guess so, and then try to figure out some hourly rate, or maybe even hire an expert to testify on his behalf. But the issue was raised, my time is up. The issue was raised not in the pleadings because my client's not required to file a response. The joint pretrial statement filed by Wife under the Nold case brought that issue before the court. Thank you, Your Honors.
Thank you very much. We appreciate the argument of counsel. We will take this matter under advisement and issue a written ruling in due course. Until then, we stand adjourned. Thank you.
Time to go?
Wake up. It's time to go.
Good job, bud.